Welcome back to the Law Show. I just want today to discuss a recent decision of the Supreme Court of Appeal, MEC for Health Gauteng versus AAS. The citation will appear. I must immediately declare my interest, or my potential interest. I expect to probably be briefed to appear for a party that will seek to intervene in the case as an appellant to upset the decision, so that I'm not an uninterested party. But the background to the decision is this. It's always been a question in law, general damages, not loss of income, those things that are measured in money, future medicals, but general damages, your pain and your suffering, your anguish, the non-patrimonial aspects of your damage, the compensation for general damage.
I always refer to it as jammergeld. It's the way for the court and the defendant to say, man, we can't put you back in the position you were. So sorry, but here's a big lump sum, and I hope that makes things a bit better.
And I like that description because I think it ties into what we're going to discuss. So it's always been a question of, well, should it be uniform, or is there a subjective component to it? If somebody handsome like Paul gets scarred, why should he get more compensation than somebody ugly like me who gets scarred? Because objectively, Paul's scarring is a real problem. He was handsome, now he's scarred. My scarring isn't a problem. I was ugly, now I'm a little bit more ugly. So there is a subjective component to general damages. And it's always bothered law students, the question of why should you differentiate. But on the other hand, if the aim of general damages is to give jammergeld, to compensate, well then surely it is necessary for you to look at the realities of this individual and how this individual was affected. And we see that throughout the law. A stoic individual, somebody who is able to overcome all sorts of adversity, might ironically receive less general damages than somebody who didn't have the strength to be stoic and who was destroyed by the event. So that's the background. The further background is that you can have a type of injury to the brain which renders the victim in a permanent vegetative state, which is a medical term. So you can have somebody who is lying in a coma on a bed, totally unaware of the fact that they were injured, oblivious to their loss. Well, is there space for jammergeld there? And in South Africa, well, before South Africa, in England, the courts appear to have arrived at the conclusion that there still is, because there is a subjective and an objective component to general damages, and where the person is totally oblivious, well, the subjective component falls away, but the objective component, and that's where I think jammergeld means, comes into its own. The component of society through the judiciary saying, jammer, you must receive some compensation, comes into it. In South Africa, we had a case called Collins in the Cape, in which the claimant was, if I remember correctly, in a coma and in a hospital bed on life support, and the court disallowed general damages on the basis, well, the victim, is totally unaware of this. The general damages would really, in reality, go to his family, and they're not the claimants. I immediately find that difficult to accept, but then I've declared my interest in the matter. In Gauteng, then the Witwatersrand, the same sort of circumstances came before court, and the courts there favored the objective component. They awarded general damages, but of course less than they would have awarded had that person been aware of their loss.
John, before you carry on, you talk about subjective and objective, and I know if you're involved in this stuff, it seems obvious, and I suppose on a purely grammatical level, it is obvious. But won't you just pause for a moment and just talk about the subjective part being my own experience of it, and the objective part being how society perceives you being
Or can I
less.
suggest, Paul, you've just outlined
I've just
it.
done
That's
it,
the
yeah.
difference between the two. So I think you've done it.
No, I've done
So
it.
that's the difference between the subjective and the objective. So what happened in AAS was it was a cerebral palsied child, and the cerebral palsied child was not in a coma, was not in a permanent vegetative state as medically defined, but certainly wasn't conscious of the extent of her loss. She didn't know what she was missing. She'd been born in this state, a very damaged state. She suffered pain. She was able to recognize, it seems from the evidence, her mother, and was able to show some recognition and that type of thing. But if you were to ask, is she consciously aware of what she's lost? Does she ever have a stage where she regrets or feels anguish over what she's lost? The answer would be no. She's oblivious to all of that.
So that's the purely subjective side of things, right?
So that in a sense you would say subjectively she is unaware of her loss. And that brings, I think anybody listening would immediately say, but is that entirely correct? Let's get back to that. The Supreme Court of Appeal, by a majority of 3-2, because in the SCA you get benches of 3 judges or benches of 5. Usually it's 5, and this was 5. 3 of the SCA justices decided one thing and 2 decided another. And the majority goes. So I'm going to leave the minority out of account. What the majority decided is that they defined unconsciousness. They didn't deal with permanent vegetative state. They defined unconsciousness as being a lack of awareness of what you've lost. And they said, therefore, this child in AAS is unconscious because this child is unaware of what she has lost. And I think so far, I could have no difficulties with it, although I do have difficulties with defining an unawareness of what you've lost as unconscious. I would have difficulties with that. But nevertheless, the reasoning was that an unawareness of what you've lost means you're unconscious, and therefore, because this child is unaware of what she has lost and is therefore, in their definition, unconscious, no award should be made for general damages in line with the Cape decision that I mentioned. And I know this case is on appeal to the Constitutional Court. I'm not going to make any predictions, particularly because of my involvement, but I just wanted to tell a story which I think stimulates one's thinking about this. It's a story of a case that I had years back for an injured person that I'll call Bertu. And Bertu suffered severe brain damage in a road accident that wasn't his fault. And he had a claim against the provincial authorities for the state of the road, and I represented him. I represented him on liability and then on quantum. And I remember these cases are always tragic, you know, when you have somebody so severely brain injured as Bertu was, that he just lay there, not seeming to respond. He wasn't on life support, but he didn't seem to respond to the people around him. He had to be fed. He could make groaning sounds, etc. The definition, as I understand it, in medical terms of a permanent vegetative state is the test you apply is you take a blanket or a towel and you place that over the head of the person involved. And if, when that is placed over their head, they don't respond, they don't try and shake it off, they just sit there. That's the definition of permanent vegetative state. And apparently, according to all of the reports except for one, which I'm going to mention now, Bertu was in a permanent vegetative state. The doctors on both sides, whose task it was to determine that, placed a blanket or a towel over his head and he didn't respond. But his family and the nurses who were caring for him in the facility close to his home where he was being kept, they told us that Bertu does respond. And I'll quickly get back to that. because I knew he does respond. I've always made it a habit of mine in the merits to go and see the person on whose behalf I'm doing this claim. Now, when you're dealing with the merits, you're not yet concerned with is Batu permanently vegetative or not. You're just concerned with, can I prove negligence? But I remember I sat on the side of his bed. I said, he was in Afrikaans, I said, Batu, weet jy wie is ek? And he turned to me and he responded. And he could only have responded, I couldn't hear the words he was saying, but he looked at me, he responded. He could only have done that because he had heard his family talking about the fact that his lawyer was coming. I'm no doctor and I can't be a witness, I'm just the lawyer. But so I knew Batu does respond. I knew that. And then we had a wonderful professor from the Western Cape, Professor Jonathan Peter, who has passed away since, who, just interestingly enough, he could have been a concert pianist, but he chose to be a neurosurgeon. And Jonathan Peter listened to the nurses and the parents who said that Batu isn't vegetative. And he conceived that what could be that in what is left of Batu's brain after his injury, you must excuse me while I just wipe away a tear, we're all human, but what's left in Batu's brain after his injury, any stranger, any person in this little world that's left to him that he doesn't know, he clamps up against. So that person could put a towel over his head, there'll be no response. But as soon as that person's gone, and Batu sees the persons that he knows, his family, his nurses, etc., he responds. So Jonathan went to see him. I must keep control of my emotions. But it was just a wonderful thing that Jonathan did. He did the test, put the blanket over Batu's head, no response. He then he walked out of the room in the hope that Batu could hear him leaving, because Batu wasn't looking. It was just, to all intents and purposes, immobile. He then tiptoed back into the room so that Batu couldn't see him, hid behind a curtain, and then he watched the interaction. And Batu was a Free State rugby supporter. His nurse was a Blue Bulls supporter. And the Blue Bulls were playing the Cheetahs of the Free State that weekend. And the nurse was joshing with Batu about who would win, and he was definitely responding. He was responding appropriately to what was being put to him. When she was saying the Bulls are going to murder the Cheetahs, he would respond not in words, but in a gesture that would say, I can't agree with you. So Jonathan Peter knew that. So now, that's the story, and it means that with Jonathan Peter's evidence, we were able to prove he wasn't in a permanent vegetative state, and wonderful for Jonathan. But to me, getting back to the AAS case, it just raises these questions. The first is, I must just find, I wrote them down, so I must remember them. But the first is that spark that Jonathan Peter was able to prove is still present in Batu, that he responds to the people he trusts and he does not respond. He's immobile with those he doesn't trust. Is that spark what's necessary for human dignity, for the law to say, we'll give you compensation because there is some spark left in you. Those who know you are able to see it. Those who don't know you can't see it. You don't show it to those who don't know you. You show it to those who do. Is that the difference? Is that what human dignity is all about? That's the first question. And I would say no. It was fascinating to know that Batu's humanity still exhibited itself in those ways. But I can't say that in those moments when you put a towel over Batu's head and he didn't respond, he didn't have the same humanity. He did. And then the second thing is, taking back to AAS, how do we know how much you know? If your brain is so damaged, how do we know? In Batu's case, all the doctors knew. They knew he's permanently vegetative. Put a blanket over his head, he doesn't respond. But they were wrong. They were wrong. Those who knew him actually knew he knows more. So to my mind, I'm sorry, I shouldn't lose control like this, but law is about human beings. But so to my mind, I cannot agree with AAS because I believe that at its heart, what it overlooks is the value of human dignity and the value of society being able to say, as Paul, you said, Jammer geld. You might not be aware of what you've lost, but we know what you've lost, and you're a human. You're worth dignity. We'll give you less because damages has to have its limits, but we'll give you something for what you've lost.
John, I mean, that's it. Maybe just as a background, there are, and certainly don't want to detract from the power of what you've just said. There are obviously, or the rule previously, before this judgment, was that if you are fully aware, you would probably get the full compensation. At the moment, CP or brain damage would be ranging between 2.5 and 3.5 million rands. And if you were in a minimally conscious state, it's obviously somewhat lower. And the question is, if you're in a minimally conscious state, are you able to perceive the loss, which is probably where AAS fits in, and then going down to permanently vegetative. And that's where the question of objective general damages of society, saying we've got to give you something because, man, we've reduced you to this. So yeah, I found that, apart from moving, I found that extremely educative. And I guess that's it, John?
That's it. Thank
So
you.
thanks for watching.
It's something to think about.
Thanks for watching, and I hope you found that useful. And let's hope that the SC or the Constitutional Court decides that it's appropriate to compensate people, even though they can't feel. We understand it might be less, but that they deserve, that human dignity dictates that they should get some form of compensation.